Philip Davies.
Very much, Madam Deputy Speaker. This is a substantial bill that's only been published relatively recently, and so I shall continue to look into some of the points that have been raised with me about the bill after today's debate, as clearly some need further investigation, particularly in relation to guns, as we've heard from some of my honourable friends. There is clearly a problem with violent crime, knife crime, and the horrific acid attacks we have all heard about. There are many things, Madam Deputy Speaker, I would like to see us do to curb these terrible crimes. The Shadow Minister knows that I totally agree with him about police numbers. For a start, that would be a good place to start. We could also stop releasing prisoners automatically halfway through their sentences and then giving them scandalous 28-day fixed-term recalls when they re-offend. We could stop faffing around interfering with the police on stop and search and let the police get on with their job. And we could also ensure that much tougher sentences are handed down by our courts in the first place to persistent and serious offenders. But this bill is clearly the government's attempt to do something. I just hope, as I do with all bills, that there are no unintended consequences. One thing that strikes me as a possible example of this is the intention to prevent online and remote retailers being able to deliver knives to residential premises. This means that people will have to pick up knives themselves. And an age of increased internet shopping will reverse that trend, forcing the general public to collect their own knives and somehow get them home. I sincerely hope that ordinary, decent, law-abiding people do not get caught up in any possession charges, for example, forgetting to remove the knife for a few days after purchase and finding that they have no legal, lawful authority to be in possession of the blade. The present situation is that if the knife is being delivered, it would go from the shop or warehouse straight to someone's home. So this is currently not an issue in these circumstances. Conversely, it also seems to me to be a very handy possible excuse for someone caught in possession of a blade. Just buy a knife every day, and if you ever get stopped, say you've just bought it as you couldn't buy it online, and then you presumably could have a legal defence for carrying it. Knives are very difficult to control, Madam Deputy Speaker, because they are everywhere. How many knives are in each and every household? And that will not change. So knives will always be very accessible indeed. There isn't really any need for anyone under the age of 18 to buy an average knife, as they will already be able to easily get hold of one if they so wish. What we can and must do is crack down on those who think it is a good idea to carry them around with a view to using them in an attack or defending themselves from an attack. On this point, I have some rare praise for the knife crime sentencing guidelines, which I understand have been amended recently and will increase the starting point for possession of a blade to more like 6 months' custody. Bearing this in mind, the sentences proposed in this bill for actions which are currently perfectly legal in relation to traders for non-compliance after this bill becomes law also range up to 51 weeks. Now, whilst I appreciate that is a maximum, I'm not sure that I think that these offences are in anything like the same league. And perhaps more pertinently, when we were discussing just the other day in this House the sentences for those who attack emergency service workers, we were told that it was right that the maximum should be set at a year. And so again, 51 weeks for a trader posting a knife to a residential address compared to the same sentence for attacking an emergency service worker does not necessarily sit well with me. Now, I just want to say that turning to the threatening offences with knives and offensive weapons, I should actually say in passing, Madam Deputy Speaker, that we ought to realise in this House that in terms of sentencing on knives, 40% of possession of knife offences attract a prison sentence, i.e. 60% don't, and 62% of people threatening with a knife resulted in custody. Again, 38% of those offences, threatening somebody with a knife, doesn't result in a custodial sentence. I will in a second. And in 2016, somebody with 14 previous knife offences was still not sent to prison for committing a further knife offence. I'll give way to the Honourable Lady.
Can I say to the Honourable Gentleman, I'm listening with care with what he's saying, and I know that he will hear me when I tell him that in my constituency and in others like mine, some young people do carry, unfortunately, because they are afraid. And simply brandishing a knife does not necessarily mean A, that they wanted to use it, B, that they were anything other than terrified by the situation that they found themselves in. I'm pleased that our courts are showing some discretion, and I would just urge him to consider carefully where he's going with this.
Well, where I'm going, Madam Deputy Speaker, is that somebody who had 14 previous knife offences, who was then convicted of another knife offence, should be sent to prison. The Honourable Lady might not agree with that. That's her prerogative. But I'm afraid to say, I think she'll find herself in a minority on that particular view. I also want to point out, Madam Deputy Speaker, and I hope the Minister will listen carefully to this, that serious offences with knife and offensive weapons, not trader offences necessarily, should come within the unduly lenient sentence scheme. And I hope that maybe that could be something that can be addressed in this bill. And I'd also like to support the extension of the principle that committing a subsequent similar offence means a mandatory sentence. I'd like to see a sentencing escalator, which means that for every time you're recommitted for the same offence, you get a higher sentence than you got the previous time as well. Now, turning to the threatening offences with knives and offensive weapons, I'll give way to my honourable friend.
A very quick point. I wholeheartedly endorse everything my honourable friend is saying. Does he agree with me that there has to be a deterrent? If there is no deterrent, then the crimes will carry on being committed and there will be no end to this. The punishment must fit the crime and people must be deterred from committing these acts of violence.
Absolutely. I couldn't agree more with my honourable friend. I'm going to give way briefly to my right honourable friend, and I'm going to make some progress, and I know other people want to.
In the same spirit as my honourable friend from Romford, the key thing is that the criminal justice system must be retributive. This is not just about treating people who are sick. It is about punishing people who are guilty. And until you send that signal out from this place, the general public will believe, with cause, that we don't understand what they know to be happening in their communities.
My right honourable friend is absolutely right. We hear very little in this place about people being punished for committing crimes, but there's nothing wrong with people being punished for committing crimes. And actually, again, on these kind of issues, this House is completely out of touch with the general public in terms of their views on law and order and sentencing and the criminal justice system. But my right honourable friend, as usual, is not. Now, I just want to make the point, Madam Deputy Speaker, in clause 27 of the bill, in fact, clause 26, I'm going to start with clause 26 first. Clause 26 of the bill, I think there's a drafting mistake in the bill, and the House of Commons Library seem to agree with me, and it is actually quite an important one. It extends the... Clause 26 amends the two acts dealing with the offence of threatening with a knife and changes the test regarding the level of physical harm likely to result from the knife. And I welcome that. I certainly welcome the thrust of what this clause is seeking to do. But as the clause is currently worded, it would still leave in law the definition of violence as being the original higher test. And this is what the Library say on this point, which hopefully the Minister will take some notes. Section 139AA4 and Section 1A2 both define the term serious physical harm, which forms part of the current wording of the offences set out in Section 139AA and Section 1A. However, the term serious physical harm is not used in the proposed new wording for the offence as set out in Clause 26 and would instead be replaced by the term physical harm. Clause 26 does not set out any particular definition for the term physical harm, nor does it amend or remove the existing definition of serious physical harm in Sections 139AA4 and Section 1A2. Now, I don't know what the government's intention is here. If they want to define the new term physical harm, then the existing wording in Sections 1139AA4 and Section 1A2 would need to be amended to set out a suitable definition. If they want to leave the new term undefined, so as for the courts to interpret, then the existing wording in those sections that I've mentioned ought to be removed altogether. I hope the Minister will go away and look at this, because I think there's been a genuine mistake. I think I know what the government's trying to do, and I think it's half done it, but it hasn't sort of squared the circle, and I hope it will go away and have a look at that again. The final area I want to cover, Madam Deputy Speaker, is I want to see a rare outbreak of common sense with regard to criminal justice legislation. And this is about clause 27. Clause 27 of this bill extends the threatening with a knife offence to further educational establishments. Whilst this is a welcome step, it does not go nearly far enough as far as I'm concerned. And so I will be tabling amendments to replace this clause to make it an offence to threaten somebody with a knife anywhere. I cannot for the life of me see why someone who threatens somebody with a knife should not be prosecuted for this offence, regardless of where the offence takes place. Currently, it has to be in a public place or on school premises. The bill would extend that to further education premises. But why should it not apply to all premises, Madam Deputy Speaker? Why is threatening somebody with a knife only an offence if it's in a public place, a school premise or a further educational establishment? Surely threatening somebody with a knife should be an offence wherever they're threatening somebody with a knife. Surely that's common sense, but the law isn't being extended in that way. Now, I'm afraid that I'm firmly of the belief that the Ministry of Justice have needlessly tied themselves in knots over this for years. When the offence of threatening with a knife was first introduced, it included a defence which was lawful possession of the knife. Now, this was clearly ludicrous and would have seriously affected convictions. Would anyone at the Ministry of Justice listen? No. How can having a defence for possessing the knife be a defence for threatening somebody with that knife? Well, the Ministry of Justice wouldn't listen. I'm not a lawyer, Madam Deputy Speaker, and I say that with some pride. And yet, with a house full of legal eagles, this bill was actually going to go through with this glaring drafting error, which had arisen because it seems to me the possession of a knife legislation had simply been copied and pasted with the threatening bit added in instead. Clearly, it is a defence to possess lawfully carrying a knife, but it should never have been a defence to threaten with it. It was only when in desperation I went to see the then Prime Minister David Cameron, and he agreed and weighed in and overruled the Ministry of Justice that the bill was thankfully changed before it was too late. And people can check the record on that. That's absolutely true, Madam Deputy Speaker. So I have a very keen interest in this particular area of legislation. The other glaring omission, which is quite possibly a throwback to the same original bad drafting, is that the offence is not committed in private premises. Clearly, possessing a knife in your home is perfectly fine and legal, naturally, but why should it not be an offence to threaten with a knife, for example, a domestic context? Now, I asked a parliamentary question on this subject last November. I asked the Secretary of State for the Home Department if she, as it was at the time, will extend the offence of threatening with a knife to incidents taking place on private property. The Minister, who's in her place, said that it is already an offence to threaten somebody with a knife, whether in public or on private property. Well, reading that literally, clearly it isn't. I then followed this up with a letter, hoping that because the government seemed to think it was already an offence, when they realised it actually wasn't an offence, they would be keen to make it an offence. Alas, it was not so simple. The latest line seems to be to say that there are other offences that can be charged. Well, Madam Deputy Speaker, I know that. But thanks to the Public Order Act, there are actually more offences that can be charged in a public place. And yet this was not a reason to stop the offence of threatening with a knife in a public place becoming law. So why should it be stopped an offence of threatening somebody with a knife in a private place? The trouble is that the various department bubbles do not always appreciate the real world, and I know of real-life actual cases where people should have been charged with threatening with a knife, but they couldn't because they weren't done in a public place. The alternative charges, which were being referred to, do not attract the same sentence as threatening with a knife, and therefore did not reflect the seriousness of the offence. Just one example was of a man in a hostel who threatened a female member of staff with a knife. He had to be dealt with, Madam Deputy Speaker, by an armed response unit, and it must have been particularly terrifying, given that the member of staff concerned knew only too well of his previous violent record, as they were housing him on release from a prison sentence for violence. As the hostel was not a public place or a school, the offence of threatening with a knife could not be used by the Crown Prosecution Service. I understand this was specifically confirmed by the prosecutor when the case came to court. So an offence with a 6-month maximum penalty was substituted, and with his guilty plea, the maximum sentence available to the court was 4 months. This would have been avoided if the law had just applied to all places equally, as quite clearly it should. I really hope, Madam Deputy Speaker, that I will get some cross-party support for this amendment so that we can actually make a positive change to this bill. I'm not perhaps always known as someone who unites the House, Madam Deputy Speaker. Well, at least not with me, anyway. So sometimes against me, Madam Deputy Speaker. But I do feel on this occasion there isn't actually a great deal for people to disagree about. There may be some resistance from civil servants who don't like any ideas other than the ones they've come up with themselves. But I would like to hear in the real world just one good argument for not taking this opportunity to change the law in this small way, but in a way that it will make it much better and much safer for many of our constituents. Threatening somebody with a knife is a serious offence and one that we should crack down on. It should not make any difference where that threatening takes place, and I hope that my amendment will be accepted in due course. I would very much welcome a commitment from the Minister to seriously look at this again. We've spoken, and I very much appreciate the time that she spent with me on this, but I would very much welcome a commitment from her today on the floor of the House that she will look at this again and think twice, perhaps, before peddling a civil service standard reply, which I'm sure she would never do, but I'm sure the civil servants would always want to encourage her to do. She must look at this herself, and I'm sure if she does, she will see that this is a very, very sensible amendment which will make a big difference to this bill.